Hello, everyone. Hannah, would you like to say what you need to say? Would you like to say? Or should we go?
Sure. Good afternoon, everybody. My name is Hannah Pythia. I'm the secretary for LACBA's International Law section. And I'd like to welcome you all to this really informative webinar today. I just wanted to encourage everyone to look at our International Law section website and reach out if you're interested in joining. I will post the link in this chat or perhaps send information alongside the PowerPoint later on. But we welcome all. We have individuals focused on a variety of international law issues, as you'll see today, including international human rights, immigration, lots of really important and relevant things. So please consider joining our section. We'd love to have you. And without further ado, I'll hand it over to Faith and Deborah to take us forward.
Thank you, Hannah.
Thank you.
Hello, everyone. Welcome to joining us for Option for Children of Undocumented Parents in case of a mass deportation. Deborah and I will cover immigration and its interplay with family law, guardianship, and adoption. Um, uh, um, First, I'm going to introduce myself, and then I'm going to have Deborah introduce herself, so we can then move on to our program and use our time quickly because there's so much to cover. I'm the principal attorney with Nuri Law Corporation. I have a license in both US and Canada and handle immigration, which is a federal US and Canada, as well as immigration as a certified specialist in California and mediator. And I've been very active with immigration, different agencies throughout the years. And I look forward to assisting you. If you have any questions for mentorship, please feel free. More information is on my website. So I'm going to pass it to Deborah to introduce herself, if you would, please.
Thank you. My name is Deborah Wald. I'm an attorney in San Francisco. Well, my office is based in San Francisco. I work throughout Northern California. I also am a certified family law specialist and the recent past president of the Academy of California Adoption and Assisted Reproduction Lawyers. And I handle a fair number of special immigrant juvenile cases. I have a background in immigration, but at this point, I'm exclusively in family law. So with that, Faith, take it away.
Thank you, Deborah. So before we start, I would like to, many of you may practice immigration law, so you may completely be familiar with the first few slides that I'm going over with others who are not familiar in order to bring everybody to the same speed. So I'm going to quickly go through some of the terminologies. So when we are using them at a later point, there won't be a confusion. Alien isn't a term of art. It's referred to people who are non-citizen. And we refer to anybody who is not a U.S. citizen in that term. Lawful permanent residents are individuals who have a green card, which you have heard that green card holder or LPR, short for lawful permanent resident. Some lawful permanent residents have that for a conditional basis for 2 years until the condition is removed. So they are CR or conditional resident. Then we have asylees, which are individuals who have a fear of persecution coming here and they seek asylum. Then we have non-immigrant or temporary visa. Non-immigrant visas are not individuals who have lawful permanent residence. They don't have a green card. That's the non-immigrant term comes about. All right. Anybody who has a visa from A to Z, if you go look in the uscis.gov, you will see that there are so many different kind of visas, visitor visa, temporary visa, various work visas, such as for athletes, for performance. Everybody got a different alphabet there. Visa waiver program are for countries that we are permitting them to come here for a specific period of time. Sometimes it's 90 days, most of the times, and then they're here for that period and they have to return back home. Temporary protective status is a status that is given to individuals who are coming here due to socioeconomical situation back home, wherever they are from, and they are here in the US. And because of that a drastic change in socioeconomic situation back home, or geologically it could be a disaster that happened in that country, their home country, they are permitted to reside here for a duration that they are authorized by our government, and that is temporary. That's where the temporary comes from. Once the country or the government consider that the situation is resolved, then they're asked to leave. Parole is a term of art. Parole are people whose body is in the country, but their status is at the border. So that means once they're coming here, let's say they have a green card, but their green card, they haven't been here for a long time, they have criminal conviction, or the person coming for humanitarian reason. So what the government does, letting them to come in, and they parole them in, and once they are paroled in, their status is still at the border. They are not having any status at the time. They're just paroled in to be here until they resolve the issue, whatever that may be. Deferred action, excuse me, including DACA, are not an immigration status. In a way, they are deferred from being deported. So they're permitted to stay in this country for a duration of that status, and that is basically from being deported. But it's not the same as being a resident or having a temporary visa. Sometimes those deferred, they're providing you, the government used to provide you work authorization, but right now, as you may know, with DACA, which are the children who were permitted to stay here, and with some other like CJIS, which we're going to talk about, they are not receiving deferred action, and that means they won't get work permit and other things. Illegal aliens is a term of art, are for people who are coming here without any inspection, without any permission. Let's say coyote bring them in. That may perhaps be the easiest way to say. But present as a visa overstay is not the same as illegal. So if a person has a visa and comes here and is overstay, that does not make them illegal. So there could be remedies, different remedies, and you should not put them all in one basket. So they're different. So for individuals who already know this, thank you for just listening in this part. I'm not going deeply into it, but for the ones who don't know, this will help them when we discuss the remaining section. Then I also have, before that, the relevant of U.S. government agencies. Department of Homeland Security, which is the former INS, was established post 9/11. It has three agencies. One is ICE, Immigration and Customs Enforcement. The other one is U.S. Citizenship and Immigration Service, and then CBP, which is a Customs and Border Protection. ICE does enforcement. You've seen them on the streets. They also have government attorneys who prosecute people in immigration courts. So ICE are enforcement investigation individuals. USCIS are the agency that administer all the paperwork, adjudicate paperwork, filings, whatever you need to file. CBP, the old INS border crossing people and the tariff are all custom officers have joined together and made up the CBP. Department of Justice, I'm assuming you all know since you're attorneys. EOIR is an immigration court, and we have is Executive Office for Immigration Review, and Board of Immigration Appeal, short for BIA, is the next agency that you appeal a decision from the EOIR Immigration Court. Department of State, that handles anything that is outside of the US. While DHS handles everything inside, DOS handles, let's say, you have a fiance you want to bring into this country. So the agency, the ministry that is handling it is Department of State. So you will file things here, paperwork with the USCIS, then it goes to National Visa Center, which is under preview of DOS, Department of State, and then you get an interview with an officer, consular officer who is in whatever countries abroad, then again under the preview of DOS, okay? Know your rights. We always put this in because it's important with the climate we have today. So this is a little bit, again, for immigration attorneys and people who are already aware. Just bear with us because we want to make sure the one who don't know can advise their clients adequately. So as you know, when you're stopped, let's say you have you have an accident, you need to give your ID, your insurance and registration. If you see there is an enforcement in your area through the police departments or through ICE, because a lot of local polices do not enforce immigration because of being a safe harbor, California being one. But, things could change in different counties. So if you see that, you don't have to provide anything. What does that mean? It means that if you do have no status in this country, one way or the other, if the ICE is there, they're going to take you in, right? So if you do cooperate and give them everything, they just take you in. If you don't, they still have to take you in, but they process you. And in order to process you to see who you are, they fingerprint you. So it takes time. So maybe that would be give you an opportunity to contact your family. They maybe contact your attorney. Maybe it would be not as fast, quicker processing for you. If you see an ICE officer or anybody knocking on your door that you don't recognize, you don't have to open the door. If they're at your business, you don't have to let them in unless they have a warrant. So if they come in, as you see, they don't ask whether, you understand that they don't have a warrant. So you will let them know if you don't have a warrant, you don't have permission to enter. We see a lot of times people ask for warrant, but they don't say you do not have permission to enter my private property without a warrant. And that is what you need, that the person needs to speak out and state that, and you can record that. Then whether they come by force, of course, they are not following the law, but that's different story. When somebody comes and says that I have a warrant and they're at your door, check the warrant. Is it signed by a judge from the courthouse, not some officer writing a warrant, because they are doing that too. So make sure it's judicially issued warrant. So check their signature and then look at the parameter of the warrant. What does it give them? Do they have permission to come check the whole house, or do they got permission to go to a specific area? And read the language of it. What does it say? If you don't know, you don't have to open the door and say, I'm gonna have my attorney review it. But if you have a warrant, you can't do that. They can come in and and basically, because of the warrant, come inside the house. But read it, and then you can ask them if they're doing something beyond the warrant. Call your attorney, let them know. I mean, these are very strange times, but you have to understand that's what's going on right now. If there is a prior deportation order, they can reinstate it on a spot. So take you in and then take you to the detention center or wherever they want to send you in order to process you first at B18 and then go from there on. I know there may be questions. We are going to answer those questions at the conclusion of our presentation. So because there is so much to cover. If you yeah, so be careful. There's a lot more to say, but I'm just want to keep it briefly. If you're living in a house and they're coming and knocking at your door, and there are more people who don't have a status in your home, it's up to you whether you want to walk outside and not let them come inside. But you and your client need to discuss all of this as to what are the options, okay? As you all know, there is no more courthouse security. In the past, during the first term of President Trump, they could come into the courthouses and courtrooms. They did that, but that stopped when California and the courts in California indicated that they do not wish for that to happen, and it was honored. During President Biden, it was indicated that it would only happen in exigent circumstances. However, that has changed, as you know. If any of you have seen the news, since what happened in Wisconsin, they can come in the courtroom and courthouses. Although California is still a safe harbor, but to what degree and how much a judicial officer can control the courtroom if the ICE are coming in is a different story. But we are getting messages from the mayor and other officials, especially our governor, that they are not welcome to do so. Now we are going to move on to paths to legalization for children. There are several options for children who are here. Most of the options I'm going to talk about applies to individuals who are not documented, and also the one who were born here, but their parents may be leaving because of ICE raids or ICE detention or potentiality of it. But so you take advantage of these. There is one Violence Against Women's Act, or what is called VAWA, is the short name for it, that was enacted, and it's there to protect victims of abuse, domestic violence. So in this case, this law actually was sunsetted, but it came back in by President Biden signing it back into the law For children under 21 can apply. If the children are aging out, they can take advantage of Child Status Protection Act. And if you are not an immigration attorney, the immigration attorney can advise you, because this is the scope of this discussion is not going to permit me to go beyond referring them, because that itself has its own, going to take an hour to explain it. So, if the Child Status Protection Act doesn't apply, then you will need to still consider that there may be other options. Sometimes they can apply through other means, through the parents, and there are other options. So don't think that everything is out the window. So they can become a beneficiary of a relative I-130, and if that person is a beneficiary, they can transfer the I-130 to 360. So let's say you're a conditional residency and you are married to someone, but you're in an abusive relationship and you don't think that they're going to help you to remove your condition. And maybe they didn't apply for your children, that you brought them in and they're the step parent. Well, you can do a 360 and then they can take advantage of it. Uh, this VAWA applies to men equally as well as women. I know it says the name, it's just that in that term is gender identified, but it's good for both gender. Under the or no gender, you don't want to identify. Under the Federal Violence Against Women Act, you can be eligible and request for a green card by self-petitioning yourself because you are a victim of battery or any kind of domestic violence. And that would be committed by either a U.S. citizen, a spouse or former spouse, a U.S. citizen parent, son or daughter. So basically, all of them are immediate relatives, as you can see. A lawful permanent resident, a spouse or former spouse, or LPR parent. So if the client is not a U.S. citizen and the perpetrator who is committing that domestic violence, they are not subject to immigration law. So they may, and you may see it now, that it's happening, that husband or wife, they, one of them doesn't want to, let's say they file for divorce, the other one doesn't want to pursue division of assets, they may be calling ICE or, trying to get that person detained and deported. So they don't have to deal with the custody anymore. They don't have to deal with the division of the community home. So there may be domestic violence, but the U.S. citizen doesn't have a penalty except maybe once you are in a family court in the context of family code, but no immigration consequences. So if the person is a victim of a DVRO, you may be able to help them to go through the VAWA process. They may have to file for domestic violence in court, in family court, and trying to protect them. For if the person who is a non-citizen is perpetrator, they have to be careful, because if they do in any form or shape get arrested and charged with 273.5 penal code, that itself is a deportable offense, is a crime of violence. So it doesn't matter if it's a misdemeanor or felony, and it's not maybe you don't think it was a big deal because you only got a slap on the back of your hand and told to go take DV courses. But that's not how it works for immigration purposes. So once you are a non-citizen, you can use a self-petition, your child can use a self-petition, and you don't have to worry about the fact that you may have, no status at this time because you are with somebody who was using the immigration as a form of control, exerting power over you. So you of course need some evidence, so try to gather those through friends who can do declaration. Maybe you file, you call the police a few times, so there could be some incident reports. The next one, and I'm sorry I'm moving fast because as I said, there's a lot to cover. There is a U visa. U visa are victim of certain crimes who have been mentally or physically abused. And in that case, Congress permitted that to provide this protection. So if you, let's say you have a family, all of them are undocumented, but let's say the husband or the wife, doesn't matter, is committing a violent act, let's say battery or let's just say sexual assault on one of the minor, you can start that the other parent can file with the police. As long as they cooperate with the police, they are able to take advantage of that, and through that obtain a U visa. But in order to qualify, it has to be one of the qualifying crimes that I have indicated here, and then they apply with the Form 918B. The certifying agency doesn't matter. It could be the prosecutor, it could be the police, it could be the district attorney's office. Basically, what they are saying is that this person cooperated with me in order, or with the system, in order for us to be able to charge this individual and then prosecute them. And that is the key. So you have to be cooperative. A U visa is pretty good because it's good for 3 years, and then you can apply after 3 years, shortly before, you can apply to get a green card. And there is no cap for family member, although there's only 10,000 per year. So if you, let's say, one family with 4 kids, you can include all the kids in there. So it's a road to green card. And any qualifying member who does not have a derivative U visa when a non-immigrant receives a green card, they're not able to become a derivative, but they still can apply through that U visa once they get a green card, and they can apply through them. So there are more options under the immigration. There is trafficking under T visa. There is asylum if a person has a fear of persecution. That said, one cannot file a frivolous claim for asylum. If one does, they are barred. It's a permanent bar. So that is not available. There is a temporary protective status, as you know, but that is, a lot of them are getting basically terminated. There is a conditional residency, which we talked about. When let's say through investment or marriage, a person is here and they have a conditional residency for 2 years, but the other party is not applying for them, or they're getting a divorce, or there are, domestic violence, or whatever it is. You have to look at the box not being a box, but how can I use this box and become outside of the box by other remedies that are available. You may have used one remedy and that may not work. You may look at it based on your evidence and facts of the case. Go toward the second remedy, not fabrication, but based on your case. So then there is a non-LPR cancellation of removal. That has been always a remedy for us. It's very hard to get. It's usually it is granted in court. You have to have the person in court. The person has to have 10 years of physical presence in US, no conviction whatsoever. Well, they can have some, but not certain crimes, but they are not big deal. In order to be qualified for this, one has to show that the removal would create exceptional and extreme and unusual hardship to the U.S. citizen or lawful resident, spouse or parent or child that is 21 years or under. There are only 4,000 that are granted, and basically that is something that you need to take into account. So my goal was just to highlight them. There is a special immigrant juvenile status. These allow children to remain here, so they can basically obtain a green card. Once the child is able to file the application for adjustment of a status, they can obtain a green card. But in order to get the CJS, they have to first go to the court. Of course, the CJS has gone through some changes, which we're going to talk about. The eligibility is whoever that is, under the jurisdiction of a juvenile court or dependency court. In California, in family court, probate court, all of them will take your case. If you actually file the proper application and form, you do have to show that there was an abuse, neglect, or abandonment by one parent or both parents. A person can become a ward of the state. It's all possible. You just have to file your paperwork. And once the person is under the age of 21 and unmarried, they may have a child while they're under age of 21, but they are not barred as long as they are not married. And then take into account, although I'm talking about California, not every state is like California. There are some states that the juvenile court jurisdiction ends at 18. We had that coming up, I think, in our Ninth Circuit a while ago, if I'm correct from memory, and we are okay in California, so we can still pursue it. Remember that if you're dealing with a HEC child, because I do minors counsel in LA and Orange, and when I had a child that was coming here and was trying to go through the mother was petitioning from another country to take the child back home, the other parent, and the children were here with assistance of other relatives, we had to look at The Hague, because The Hague doesn't consider a child that is reached 16 or over to be a child anymore. So it was a one way for us to terminate The Hague in order for the child to get CJIS was for me to schedule a hearing a day of that the child was turning the age 16, if I could push it that long, or a day after. So then I can object to The Hague and ask the court to close it. So you have to know the statute in order to be able to help your children in this case. So under age of 21, you have to show abuse, abandonment, and neglect. And once you do showing that, you have to go to obtain a valid order. Of course, it's a judicial officer ordering it, either through family court, guardianship, dependency, or delinquency court. Must find that the parental reunification in dependency court is not viable. And court must find that it is not in the best interest of the minor to return them to their country of origin, or to the parent, or their habitual, residence, whatever that may have been. Once the person is seeking it, they have to file a Form 360. The Form 360 is a USCIS form. The name, it doesn't say, it's an or, so this form also applies for special immigrants. And you need to, identity is important, so make sure they have their passport or birth certificate, because USCIS needs to make sure the person that are reviewing their application, their identity is as they claim it to be. Copy of the court order showing that this has been already declared, there was a finding by the court, and evidence. If they have been a ward of a state, you would need to get a consent from Department of Health and Human Services, and there's a process with that. So normally we would say a person is inspected and admitted in the United States, but it is expressly stated that for purpose of the CJIS, the petition is treated for the purpose that the beneficiary has already been paroled. So basically look at the INA if you want to, an HCFR, to give you more information. If there are, the beauty of CJIS is that there is no bar except the terrorist bar, so terrorist-related adjustment of a status bar. If you are not practicing immigration, you may say, what is bar? Bar prevent the person from achieving their goal, let's say. So if a person is inadmissible, meaning that they cannot be admitted into the country, so when you file, let's say 360, you still want to get admission as CJIS. So if they, committed a terrorist related, let's say in this case, charges that were laid against them, then that would prevent them from it, and there is no waiver in this case. So basically, in many things there are waivers, but some things are not. So admissibility is when you want to enter the country, you want to adjust your status, so you need to show that you meet all the requirements that they're asking you. And now I'm going to pass the baton to Deborah for immigration and adoption. Thank you.
Thank you, Faith. That was impressive how quickly you got through all of that. We will try to have time for questions at the end. So if any of you got lost, please make a note of your questions or put them in the Q&A, and we'll come back to them. So I'm going to talk a little bit about adoption, and I'm going to talk a little bit about guardianship. And Faith is going to jump in to help with some immigration issues along the way. So for those of you who may be unfamiliar with adoption, adoption is a confidential process. If you go to do your online case searches, you won't find any adoption cases. There's no public record of them. They're confidential from start to finish. There are ultimately three kinds of adoptions, and the fourth is sort of a subset. An independent adoption, which is mostly what we deal with in the context we're discussing now, is when a birth parent directly places the child with an adoptive parent or adoptive parents with no agency involved. So this is the neighbor saying, I can't keep my child, can you take my child? Or within a family, asking the aunt to adopt, those kinds of things. Those are all independent adoptions. If they found each other independently, there's no agency involved. Step-parent adoptions, we also actually see a lot of in the immigration context, is the adoption of a child by a step-parent or domestic partner of a legal parent, where the legal parent retains custody and control of the child. So it's as well as, not instead of. So the most common example is a couple has a child, they're not married. Later, one of them gets married. The primary parent gets married, and the primary parent and the primary parent's spouse are raising the child together. And at some point, they decide they want the primary parent's spouse, who is a step parent, to adopt the child and become the child's parent instead of step parent. That's a step parent adoption. Agency adoptions are done by licensed adoption agencies. I'm not going to get into inter-country adoptions, which is a whole other separate category I should have put on this list. With Hague Convention countries, inter-country adoptions have to go through the central agency of each country. This is to avoid child trafficking, but it's a complicated process, and you have to be careful because an inter-country adoption done wrong can become a bar to adjustment of status later for the child. So be super careful. I would not, this is not something to do at home. Make sure you have experts involved. And then just as a heads up, which can be useful in this context, in California, we actually will allow adoptions that cause children to have more than two parents. So if you're in a situation where someone is potentially being detained or deported, they want to make sure the child has a path to remain here with, for example, a mixed immigration status family where the child's a US citizen. They want to make sure they can remain here. They could find someone to adopt the child, a friend or a US citizen relative, whatever, without their parental rights being terminated. It is a potentially nice way to allow an addition for the safety of a child without subtracting a caring and fit parent. Okay, now my arrows aren't working. Faith, can you see if you can? Okay. The other thing, going along with what I was just saying about, non-confrontational ways or conciliatory ways to do this, is if the parents' rights are being terminated, but there still is a loving relationship there, California law provides for enforceable post-adoption contact agreements. So if the placing parent or the relinquishing parent's rights are being terminated, but they want to have an enforceable right to continue to have some contact with the child, the adopting parents and the relinquishing or placing parents can enter into an enforceable post-adoption contact agreement. It can be all kinds of things. It can just be photographs once a year. That's a post-adoption contact agreement. It could also be, weekly unsupervised contact. It can be whatever makes sense in that scenario. The most important thing to understand is that when a parent's rights are terminated without a post-adoption contact agreement, the parent loses standing to raise any issues in the court with relation to that child. In relation to that child, their rights are terminated. They're now a legal stranger to the child. If there is a post-adoption contact agreement, everyone retains standing. Okay. This is you, Faith. Go ahead.
Sure. So just to be clear, for adoption, if you're pursuing that for the children, you do need to know if you're doing it for immigration, in this case, which is the topic of our discussion. This has to take place before the child reaches the age of 16, and then you have to show that there was a 2 years that the child was residing with the custodial parent, whoever that is adopting the child. There is a lot to be said, except that because of the time, and I want Deborah to have ability to finish her section fully. Just want to say there are variation. There is a difference between a Hague process and a non-Hague, which is called orphan process, and the other one which you are filing petition for a relative. And there are some exception that the 16 can be extended to 18th, but that is if there is a sibling. And again, those exception are rarely come. So I'm gonna it is provided to you, but I'm gonna hand back to Deborah so she can go ahead. I think that should be sufficient for now.
Okay. And again, I just want to give everyone a heads up. So ACAL is in, I don't even want to say it that way. There's a disagreement between some of the attorneys and the California Department of Social Services. So for an independent adoption, the California Department of Social Services is responsible for investigating, doing a home study, and determining whether the adoption is in the child's best interest. Actually, Los Angeles is one of a small handful of counties in the state that use their own county agency instead of the state Department of Social Services, but they're governed by the same rules. And California Department of Social Services from time to time puts out all county letters or ACLs that guide the state on policy. And in July of 2020, they put out ACL 20-69 on when a adoption of a foreign-born child who is present in the United States can be treated as a domestic adoption versus an inter-country adoption. The Department of Social Services does not handle inter-country adoptions. Again, those have to be done through accredited agencies that are accredited specifically to handle inter-country adoptions. They're not handled as independent adoptions ever. And the position that the Department of Social Services is taking in ACL 20-69 is that in order for an adoption of a foreign-born child to be treated as a domestic adoption, the child has to already have been granted either lawful permanent resident status or been naturalized as a US citizen. So children who are here with political asylum, children who are here who've been accorded special immigrant juvenile status, even if they've been here for years, DACA kids, whatever status they're in, if they have not been granted permanent resident status or US citizenship, the Department of Social Services is refusing to proceed with those adoptions as domestic adoptions. So this is something people need to be aware of. I'm contacted fairly frequently with people who want to do adoptions of a child who's present in the United States, including lawfully present in the United States, including SIDGE kids. And we're working with DSS to try and get that policy changed. But at this point, they will not proceed on those adoptions. They recommend denial. And I am aware of at least a couple of cases where courts have then overridden that recommendation and ordered them to move forward. And they will move forward if ordered to do so, but it's going to be a fight. In terms of guardianships, so that's the other option for someone to get legal custody of a child so they can make all the necessary decisions without going all the way to adopting. So the biggest difference between adoption and guardianship, well, the two biggest differences are guardianships are temporary. They don't have an expiration date. They could be temporary until the kid turns 18, but they're not considered permanent in the way an adoption is. Someone can bring a motion at any time to set aside a guardianship and the court will hear it. And the other thing is the parents' rights are not, parental rights are not terminated in a guardianship, whereas they are in an adoption. So guardianship grants custody without a termination of parental rights. Next. They're not confidential as opposed to adoptions. Guardianships are searchable. They are public records. Most counties, many counties actually are allowing remote hearings, which given everything going on at courthouses, if remote hearings are an option and people are worried, they're really a nice alternative, way less stressful, and also typically less expensive because they involve way less attorney time. Guardianships are handled in the probate courts, which is sometimes challenging because the probate courts are not actually well trained on dealing with custody issues. And again, guardianship is a form of custody. And so you're arguing about what's in the best interest of children in front of judges who that is not typically what they're doing in probate court. And you should just know that because it's probate courts, so probate courts, for the most part, they deal with conservatorships and they deal with death. they are not used to having competent, alive people in front of them. And they are the ultimate eye dotters and crossers because of that, because typically the parties who they're addressing aren't able to advocate for themselves. And so filing guardianships, I always tell people to assume they'll be rejected at least once, just because there's some local form you missed or some I wasn't dotted or T crossed. Parents can consent to the guardianship. That's the easiest thing to do. And once a child has been in, so there's temporary guardianships, which are like an ex parte. They're an emergency process if there's a necessity for a quick guardianship. But the actual general guardianship, go back for a minute, the child has to be in a general guardianship for 2 years before the guardians can apply for adoption. But at that point, the standard is actually much lower. You don't have to show unfitness on the part of the parents. All you have to show is the child has been there for 2 years and that it would be to their benefit to remain there. It's part of providing stability for children. Okay, and there is a way to safeguard records to avoid public disclosure, but I don't have time to go into it. We can talk about it during the Q&A if we need to, or if people have questions. So guardianship, this again, you can read this for yourselves. Basically guardians stand in the shoes of the parent. It does require formal. I often hear people saying, oh yeah, and I'm the guardian. And what they mean is the parents wrote a letter saying this is going to be the guardian of my child. To actually have a guardianship, you have to go through court. You have to get a court order. And you can get a fee waiver, and it's actually based on the child's financial status, not the guardian's. So even guardians with money can get fee waivers if they're adopting a child who has no access to any financial resources. And guardianship, to show a court why a child needs a guardianship, is actually very comparable to showing a court why a child qualifies for special immigrant juvenile status. So it's a very easy combination to petition for guardianship and for special immigrant juvenile findings. And you should, of course, make sure whatever reasons you're giving why the child needs a guardian should be consistent with the reasons you're giving about why the child qualifies as a special immigrant juvenile. Next. Okay, there are, like I said, you can petition for temporary. There are 2 types of guardianships: guardianship of the person, guardianship of the estate. With most of these cases, certainly with all of the ones I've dealt with where we're looking at special immigrant juvenile issues, I've never had one where the child had an estate we had to worry about, but if there is, you should just know you can have someone appointed a guardian of the estate who then has a right to deal with their finances. There's a fairly significant level of reporting required. The court wants to make sure no one's being taken advantage of. The temporary is the GC 110 series. The regular guardianship is the GC 210. The temporary does not require an investigation, but the permanent or the long-term guardianship does. It has to be investigated. Counties vary as to who they have investigating it, whether they have probate investigators investigate it, or usually the alternative is they'll refer it to CPS, and you'll need to reassure your clients that if CPS is investigating them, it's not because they're suspected of abuse or neglect. That may just be the agency being used by the court to investigate guardianships. If the child is over 5, they'll have to appear at least once. Again, remote may well be okay depending on the county, but the judge wants to see the child and often see the child at least once with the guardians and see that it is in fact a healthy situation. And the court actually maintains, the child is referred to as a ward. The court maintains jurisdiction until either the child ages out or the guardianship is terminated. And there's actually an annual report required, but it's just a form. They fill out a questionnaire and submit it once a year, and then hearings are waived as long as everything appears to be in order. But the court will keep an eye on things with a guardianship. Next. So the standard for having a guardian appointed is whether it's necessary or convenient. It's taken from the family code, and they look at the best interests of the child status under the code. I gave you the code sections. The most important language is that it's the public policy of this state to ensure that the health, safety, and welfare of children shall be the court's primary concern in determining the best interests of children when making any orders regarding the physical or legal custody or visitation of children. And so, again, the guardianship, although it's under the probate code and the procedures are set in the probate court, the standard is referred to the family code custody sections. Generally speaking, a guardian is granted instead of a parent, not as well as a parent. The parent loses custody when a guardian is appointed. However, historically, there's been an exception when a parent is terminally ill, so that they can have someone appointed a joint guardian, with the idea being the parent can continue to act as a parent for as long as they're physically able, for as long as they're medically able, but there can be a smooth transition when the parent no longer is able to parent without having to go to court then under traumatic circumstances. And there's a bill before the legislature I wanted to make sure you were all aware of that would expand that to include situations where a parent is being detained or deported. So there may be, again, you should, if you're interested in this, you should follow AB 495. It's making good progress so far. If it passes, a parent who is being detained or deported, facing deportation, facing removal proceedings, could be appointed a joint guardian with the person they want to take care of the child during a period they're unavailable, or if they actually are removed from the country, without their rights being terminated through an adoption, and also without losing custody, so they can keep engaged as a parent in all the ways they're able. So this could become a really nice way to help protect some of these children without removing whatever rights their parents are able to continue to exercise. So I think
Yes.
that, yeah, you're not.
Okay, so I'm just gonna now go and cover this quickly, and then we're gonna take the questions. So if, let's say, none of the options that Deborah just went over so beautifully, and I went over immigration portion, doesn't apply, then as Deborah mentioned, you could do under guardianship or separately. You can do an affidavit whereby you give a power to a person. So under 6552 of Family Code, a relative, and the relative is pretty much a very big definition of relative. It's like that. So it's not an immediate. You can do cousins, nephews, and great and grand, whoever that is has that can be included.
And
And
even steps, which is really helpful, step parents, step siblings.
yes, all of them are there, and you know you can use it for school enrollment, for medical care. You don't have to file it with court, doesn't have to be notarized. But my suggestion is the best practice to notarize everything. The AB 495 that Deborah was just talking about modified the 6552 and 6550 and another health and institutional code. So basically, it expands to include the relative to non-relatives, but also a lot of people who had this affidavit and the other affidavit that I'm going to talk about found it very difficult in order to be able to get any school records or cooperation from a school. So this AB will prevent that and make it easy for the family to be able to appointing a third party to have access to all those records. Also, since there are a lot of ICE going into schools, they don't want the children to be separated or be taken from the daycare providers. So now this bill requires them, the healthcare provider or the daycare provider or daycare provider or the school to contact the agency that they're being directed when somebody is inquiring about the immigration status of these kids or whether they're asking for records of these children. They would immediately have to inform the agency that they are under, the educational institute. So basically preventing people from coming in and trying to obtain these records or trying to take these kids out, and also make it easier for non-relatives who have affidavits to be able to get cooperation from a school. And that is what is going to be changed. I have provided in your handout a copy of what it would look like, which I'm going to go over it after this. The next one is the authorization for care to provide for medical and dental only. That's a limited one under 6910. This can be any adult. It doesn't have to be relatives, and it's definitely notarized. And then there is also the guardianship. There is a Judicial Council 207, which compares and talk about those. I provided that for you so you can see it, as well as I think there is a memorandum being included from June 6th regarding the changes with CJS and deferreds, which I thought it was important for you to know by seeing the memo. So let me see if we can, we do have some questions. So we forgot to let you know, yeah, you can put the question in the Q&A or in the chat. It's all good. Um, uh, they said, does one have the right to ask for a warrant in their native language? You know, I haven't done a research on that, but since we are in US, if you don't understand something, I guess if the person impede that, then it will not be, I mean, it would be hard to prosecute them if they are not, they're impeding a warrant because they didn't understand what they're being said. So, but I think a warrant, once is granted without doing a research, is a court order and it has to be abide by. So if the person doesn't understand that, they may or may not be arrested if they try to prevent the execution of the warrant. And then, you know, at some point their attorney will argue that they didn't have the mens rea because they didn't understand what's being said. So I would think that would be the answer to your question. But again, without doing a research, I'm just saying it from the personal knowledge. Deborah, do you have anything? I don't see any other question. I think that was the only thing I saw.
We covered so much material so fast.
Yeah, I can show them
Yeah, let's go over the handouts, and while you're pulling them up, let me just make a comment about the NRFMs, the non-relative extended family members. It's a concept that's very familiar with the dependency courts, the juvenile courts, because custody can be given to NRFMs. That's what they're called, the non-relative extended family members. It's not a familiar concept to people who don't actually practice independency. But if you just think about your community, you know, that's people's aunties who aren't actually biologically related. Many children and young people have people who could qualify as non-relative extended family members because they've always acted in the role of grandma, or they've always acted in the role of auntie, or they filled the role of dad, or whatever it is. And so it's really important to start to pay attention to who those people are, because they may be able to get standing as non-relative extended family members that will allow them to act more quickly and efficiently to protect children.
So this is the guardianship information regarding you know, basically what we talked about. It talks about the comparison of them, of guardianship with a caregiver. If you need to use a caregiver authorization affidavit, this is the one that I provided you a template. I think I got it from some website, or it's court website. So basically you can use that, and it's always best practice to notarize it. Yeah, and then especially in this one, I think it requires you to notarize it. But in the other one, 6910 doesn't, and I still suggest to notarize it. And this is a good option if you are not sure whether you know, you're detained, your client is detained by ICE, and they want to make sure somebody will be here because the kids are whether they were born here already, so they are not going back home, they don't want to go back home, or the parents don't want to take them back home because they are uncertain as to what they're going to face when they go back home because they haven't been there for 20 years. So those are the options you could do. There is a question you said.
Yeah, there's an adoption question. What supporting documentation should an appointed custodian have in support of an independent adoption? So an independent adoption, I mean, I guess I can take a couple of minutes to go through. So an independent adoption, the first thing that's required is that there has to be a placing parent. For an independent adoption, typically, there has to be a placing parent, and the placing parent is entitled to 2 sessions of counseling with someone called an adoption service provider to make sure that their consent to the adoption is a knowing and voluntary consent. This is part of the state trying to have no more cases ever where children get placed for an adoption and 6 months later it turns out it was the person placing them didn't understand what they were doing. And then you file an independent adoption petition with the court, and then you provide that to the State Department of Social Services or the designated county agency in the few counties that designate agencies, local county agencies, and they're going to do a whole investigation. It's a 6-month process. There's a lot of paperwork involved. And but to file, all you need typically is that independent adoption placement agreement that has been witnessed by an adoption service provider and your petition. And then once you provide that to the Department of Social Services or the designated county agency, they'll let you know everything else they need. Their fingerprints or live scan, there's employment verification. They'll do 2 home visits. There's a lot. There's extensive questionnaires. There are health questionnaires for the birth parents, and there are a lot of questionnaires about the backgrounds of the adopting parent or parents. So there's lots of paperwork, but you'll get that from the Department of Social Services or
Yeah.
the county agency.
Yeah. So, okay, and if we don't have any more questions, then we are just gonna cover a couple of items that we ran through them. Um, okay, and that is there are some changes to the CJIS, and that is not unfortunately right now when you file the 360, you are not getting deferred anymore. By not getting deferred action, that means deferred action, as I indicated at the beginning, as in terms, what it means, it just prevents the person from being deported. It means that they have a permission to stay. It doesn't give them any kind of a visa. So that deferred is not taken away. By taking that away through the USCIS, doing that, they did that not just to that, they did that to all the new filed DACA as well. So what is happening is that they're all pending, sitting there. So they are not giving them the deferred. If people had that, they just kind of have it until it expires, and then God knows, what will happen. So when a person doesn't have a deferred, then they don't have protection from not being deported, picked up. And that is the problem right now. So we have.
So, yeah, this is hugely important. Thank you for bringing that up. And I just want to say, from my perspective, it is giving me pause about whether to actually apply for special immigrant juvenile status if the young person is not yet on the USCIS's radar. So if I have a child who came in and is already in removal proceedings, or I have one right now I'm working on who was granted asylum. Actually, that's not a CJIS case. I have some children who are admitted on student visas. If the USCIS already knows who they are and where they are, then if they qualify for special immigrant juvenile status, there is no downside. The wait for adjustment of status for those kids right now, though, is estimated at 6 to 10 years. There are not resident visas available. And so with this announcement by USCIS that they no longer will grant them deferred action status, you do have to think about, do you want to again, if they're not already on the USCIS radar, do you want to let USCIS know who they are and where they are, given that there won't be a visa available for 6 to 10 years, and USCIS could put them in removal proceedings? So there's a lot of efforts to change that, either by making visas available more quickly, or generally changing the classification, or getting them to roll back that policy memo. Do you want to add anything to that, Faith? It's very alarming.
Well, the only part I would like to add is that even though if they're not under the radar, because of the registration requirement that was put in there, if there are no, some kind of the forgiveness, whatever, for lack of finding a better word, or a waiver, they, from experience post 9/11, when we had registration requirement for 26 Muslim countries, whoever didn't go and was afraid to go register, they used that to deny their petition or application. So we anticipate that at some point in the future, from past practice that I observed, and I was the chair of the registration NCRs for years, until it kind of didn't need to be, because it went away, and then 2011 President Obama just got rid of it. But unfortunately, these individuals who were required based on a new registration requirement didn't register. They will be likely subject to not complying with immigration law, not complying with the registration requirement. They may not do any penalty for fine or misdemeanor, but what would be looking at, like what they did to the Muslim community, is not giving them their application or petition and say you didn't comply. So it is imperative for attorneys who know if you have a client who is not compliance, to document what is happening in course, how ICE is breaking the law, how they are, taking people, not giving them due process, sending them to other third countries. It's imperative for you to do that, because there will be a day that you may have to file this stuff in order to justify your client's action because of unlawful behavior of the government at the time. Maybe your client is an asylee, and there's an international treaty that they cannot be sent to another third country or their own home country. So you're going to have to use whatever your toolbox is going to have, which is what I did when I was doing NCRs. So I was helping those people by going through my toolbox and see what I can go to argue to make sure that this person is able to overcome the situation, and because usually they send you a request for further evidence, and then you respond to RFE. Well, this is the reason why this person didn't register. So be kind and try to start accumulating everything that you're getting. At some point can be used. So start documenting and start seeing things on the paper, a memorandum, whatever that you think is going to be useful tomorrow, save them. Well, thank you, Deborah. It was a pleasure,
Thank you, Faith.
for both of us to be able to be invited by International Section and Hannah and Karina. We appreciate you. I hope you all benefited or enjoyed this, and this is in some way useful and helpful to your client and your practice. And if you're able to do any kind of a pro bono, we try to keep this very reasonable price-wise. God bless you, play it forward. We would like people to be able to receive some kind of assistance, and that's all I can say. I see the CLE certificate will be mailed between 7 to 10 days. Your handouts is in the chat, and God bless you all. Thank you, Deborah.
Thank you so much. Have a good rest of the day.